This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
Thank you for joining us today for class number 7 of our 2021 Virtual HOA Condominium Academy. We teach these in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe. And I'd like to thank all of them for that partnership. Since the pandemic has started, over a year ago, we've transitioned now to virtual classes and working together. And we found that working together on these classes and doing them via Zoom is better for everybody right now. And we're able to get higher attendance and we're able to get a lot of great information out to all of you. So I'd like to just thank all those different cities for partnering with us to provide these classes today. I'd just like to start out by saying my name is Beth Mulcahy, for those of you who may not have listened in on a class before. And I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed representing associations for the past 24 years, almost 25 years. And my firm currently represents over 1,000 community associations throughout the state of Arizona. And so I feel like I have a wealth of knowledge from almost 25 years of giving legal advice to associations and teaching many classes. And also I've served on my board where I live for over a decade. So I think I have some interesting perspective for you here today on how we can best deal with people problems. So welcome to all of you for being here today. Let's talk a little bit about what are some of the topics that we're going to be discussing here today. We're going to give you some tips on how HOAs and condominiums can best handle people problems, such as mentally ill owners with dementia or Alzheimer's, the village sociopaths, right? The sociopath in your neighborhood, hoarders, difficult personalities, infighting on the board, and feuding neighbors. And something really kind of funny happened to me yesterday. A manager that I've worked with for over 20 years sent me an email when we sent out a reminder for the class. And she said, I don't know how in the world you will be able to address all of these different topics in 1 hour. And I kind of chuckled when I opened that email and read it. And I responded back and I said, tune in, I'm going to get it done. And so I think what you're going to find today is, as we were preparing for this class and thinking about what would be the best way to communicate how all of us can manage these different personalities and people problems, there's a lot of common threads. And so I think that you'll find that a lot of the same people problems, we have the same strategy on how to deal with them for different types of problems, whether it's somebody who's mentally ill or maybe somebody who has some aging disorders like Alzheimer's or dementia, or even hoarding, which is to a certain degree a form of mental illness. So we're going to give you the tips and strategies that we've learned over the years to help make your job more enjoyable and easy, and to give you strategies so that you can get positive outcomes for your associations. We're also going to be talking about the 2021 Arizona legislative session. What happened this year? It was one of the longest sessions that I've ever witnessed in over 20 years. So we're going to talk about the 4 bills that passed this year. And really, there's only 2 that are of significant impact for associations, in my opinion. So we're going to be covering that as well. So I always like to know who's in my audience. So I'm going to do a little poll here. So the question is, in which city do you reside? And the reason why we're asking this today is because we like to know who our audience is and which cities are represented in this class today. Then we can get the results back to everybody, and I can maybe tailor my presentation more specifically to the communities that are represented here today. Okay, so we've got the poll results in. Looks like Scottsdale has a really large representation today. So we have about 11% from Chandler, 3% from Goodyear, 8% from Mesa, 3% from Peoria, 28% from Scottsdale. I think that email that Bruce sent out yesterday really helped get a lot of people in attendance today. 2% from Surprise, 3% from Tempe, and then 41% from other. So just like to welcome everybody here today. Thank you so much for joining us. And we're going to try to get some more residents from some of the cities that weren't represented here today. Okay, the first topic we're going to be talking about is how to manage an aging condominium building. It really wasn't one of the topics that I was scheduled to talk about today, but in light of the Champlain Towers South condominium tragedy, I thought it was important that I just spend a few minutes talking about it with you. So first, we would like to, on behalf of myself and our firm, we would like to offer our most sincere condolences to the victims and the families that are impacted by the recent events at the Champlain Towers South Condominium Association in Miami, Florida. It's just a sad tragedy, and watching it unfold has been just incredibly sad for everybody in our country and our world. And I think this tragedy does provide some valuable lessons for board members of high-rise condominiums. And I think, whenever there's a tragedy like this, we always try to look for positives. I think some positives that we can take from this would be that we're learning a lot about things that associations that are high rises can do differently or better so that we don't ever see a tragedy like this again. So first, if you are a high-rise condominium in Arizona, or if we have somebody from another state listening in here today, you really should consider having a 360-degree inspection performed by a structural engineer as soon as possible of your building. In the event that the inspection reveals any potential structural issues, you should be reaching out to your trusted advisors, your attorney, your management company, your insurance agent, your reserve specialist, to come up with a plan as to what you need to do to protect the structural integrity of the building in a timely manner. So that would be, my most important recommendation here. So you should have a structural engineer come out and do an inspection of your building. Even if you think there isn't anything that is, wrong, like, visually you can't see anything that's specifically wrong, just for, to keep everybody's anxiety in check. I know that a lot of condominiums have been reaching out to us the past few weeks saying, what can we do? We don't think we have any problems. So we have a lot of owners in our community who are really worried about this. So what are some things that we can do to provide, some assurances to the residents that, we are on top of this situation? So first thing would be have a 360-degree inspection performed by a certified structural engineer. CAI National, the Community Associations National, has done a fabulous job creating resources to help high-rise condos in light of this tragedy. And so I would also recommend that you go to the CAI website, and my office is going to be sharing the link for that. They have a ton of additional resources on condo safety, structural integrity, maintenance, and reserves. And I just see it being shared here on the screen right now. I'd encourage you, if you're a high-rise condo in Arizona, to take a look at that, because it has some great recommendations and things that you can do in your communities to make sure that things are going well. And that, that the structure is being maintained. And if you have any problems, what are some things that you can do? Okay, just a final note on this is that our firm is also now offering a high-rise condominium boot camp to discuss many structural and maintenance issues facing high-rise condominiums, such as a lack of reserves, what type of insurance you should have, is there insurance for the type of thing that happened in Miami, how to interpret and act on engineering reports once you receive that 360-degree report, how to handle deferred maintenance, and then how to fund repairs by special assessments, use of your reserve fund, or even getting a loan to pay for maybe some of the things that you need to do in your community. So this special one-on-one boot camp with myself and any high-rise condominiums in Arizona is really a great way for high-rise condominiums to relieve anxiety right now and get an action plan in place for your community if you have certain things that really need to be done in your community. So you can contact me at 602-241-1093 at the Mulcahy Law Firm if you're interested in hearing more about the boot camp. Or you can contact our firm at info@mulcahylawfirm.com with any questions. Okay, let's switch gears and talk a little bit about the 2021 legislative session. It finally ended. It ended on the last possible day it could end this year, on June 30th, 2021. It was a weird year in the legislature. I think we can all agree with that. The COVID bills, the budget disagreements, the recall, trying to look at all the ballots from the November elections. And, it's just been a really odd year in the Arizona legislature. Let's just chalk it up as that. And personally, I'm pleased that we didn't have a lot of overcorrection type bills for condos and HOAs this year. And so really, there are just two main bills that I want to talk about that I think have an impact on our industry specifically. And then two bills, one's kind of going to be a little bit moot because it deals with masks, and then also about being sued for COVID. Those are kind of the ones that I don't see as being into play as often as the first two bills. So let's talk about the two bills that were passed this year that I think will directly impact you. All of these bills, just so you know, as a starting point, will be going into effect on September 29th, 2021. So, there's a couple months for us to get up to speed on them and to, educate everybody in Arizona and our industry about what some of the changes are. And these bills will go into effect September 28th, 2021. So the first bill is House Bill 2170, and this deals with attorney's fees now being able to be recovered when we file a garnishment against an owner. So basically how this bill is going to go into play is that previously we were not, associations were not allowed to collect attorney's fees and when they were pursuing a garnishment against an owner. So how this comes into play is, let's say you have an owner who doesn't pay their assessments or who doesn't pay fines, and the association goes to justice court or superior court and gets a judgment against the owner. The judgment is basically just a piece of paper, right? And so we take that piece of paper and we have to collect on it and get the owner to pay. And so one of the ways that we can get the owner to pay is we file a garnishment. And the most typical garnishments that we file are, we have the court order that the owner's assets are garnished. And it could be their bank account, it could be their wages, or it could be their rent if they're renting a property in Arizona and we're trying to get the tenant to pay rent to the association to satisfy the debt in the judgment. So the great news about this new law, House Bill 2170, is that now attorney's fees can be collected when previously we weren't able to collect them in garnishment matters. So this is a positive bill for our industry. And our firm had a firm meeting last week. We were discussing how we're going to be implementing this starting September 29th, 2021. So it's a good thing if we get a judgment against an owner and we go the route of garnishing an owner's bank account, their employment, their wages from their employment, or if they have a renter, the rent, to satisfy what's owed to the association by a judgment, we now can get our attorney's fees. So that's great news. The next bill I want to talk about is Senate Bill 1722, and this talks about political signs. We're going to see this be an impact in any primary elections or any regular elections that take place in Arizona on a state or national level. And basically what this says is it extends the time a political sign can be left up on an owner's property to 15 days after the general election, or if the sign is for a candidate in a primary election who does not advance to the general election, 15 days after the primary election. And so it just gives owners, it's kind of like a sign of the times, right? We've had a very political year and a half. And basically what's going to happen is that owners are going to be allowed to keep their political signs up longer. Previously, the law was just 3 days after the election. Now it's been extended to 15 days. So we'll start to see that come into play. Obviously, September 29th, this bill is going to go into effect. The next round of elections will be the first week in November. So we'll want to make sure that we're aware of that and mindful of that, and not sending a violation letter if the political sign, they are allowed to keep the political sign up for 15 days after that election. Okay, then the next two bills I'm going to talk about are basically COVID-related bills. House Bill 2770 talks about mask mandates, and basically this is hopefully going to be kind of moot, assuming that we don't have any new mask mandates in effect. But basically what it says is, notwithstanding any other law, a business in the state is not required to enforce on its premises a mask mandate that is established by the state, a city, town, or county, or any other jurisdiction of the state. Now, again, I think this is probably kind of moot because, there are no mask mandates in effect right now. But if something happens with this new variant of COVID where we have to go back into masks, please, I hope that does not happen. The businesses would have an exception under this law. And obviously, you can probably guess this was passed early in the legislative session. This is one of the first bills passed in this legislative session in January or February. So it's probably moot now, but it's notable and I wanted to mention it. And then the last one is Senate Bill 1377. And this talks about civil liability for associations that are nonprofit corporations or really any other business in Arizona. And basically what this law does is it makes it really difficult or nearly impossible, in my opinion, for plaintiffs to prevail regarding a pandemic-related lawsuit, so long as the associations was acting in good faith in the decisions that they were making. So this is a liability limit, where associations, aren't going to be held liable if they're sued. The plaintiff would have to prove that the association was acting in bad faith. And so I think it's going to really limit the number of lawsuits that would ever be filed against an association for any COVID-related issues. So again, kind of a slow legislative year this year in Arizona with our legislature. All these new bills will be going into effect September 29th, 2021. And we're going to be sharing right now our firm's most recent legislative update summary in the chat feature on Zoom and in the comment section on Facebook. And as always, any of our publications that you see that we're talking about in these seminars or virtual seminars or on our blog or whatever, they all can be found on our website too, at mulcahylawfirm.com. All you need to do is just click on our cheat sheets tab on the homepage of our website. Now let's switch gears and talk about people problems. The one thing I would say, just from a, in the trenches kind of analysis, people problems are a driver in associations. I mean, no question about it. We almost every day in my law practice, I am getting questions from board members, managers regarding people problems that are happening in their community. And how should they handle them? This is a unique situation with, somebody that potentially has mental illness or a hoarder or somebody that has some aging issues. And so this is a very common topic for our industry. One thing that I can tell you is that also when I have been serving on my board, I will say that the things that caused me as a board member and me as when I was the president of our association, the most stress was what? People problems. And so I thought it was really important that we bring this issue together here today. And we talk about what are strategies that associations can implement so that we can manage these people problems better. And so that we can eliminate burnout of board members and stress of board members and stress of managers, burnout of managers. Because let's face it, these type of problems, they are the type of problems that people don't want to deal with. And that's what causes managers to switch properties or quit, and board members to just say, I think I've had enough of my volunteer time on the board. So let's talk a little bit about, what does this look like in an association? So I think we can all agree that we all live in close proximity, especially in condos, but also in HOAs in Arizona. And so whenever we live in close proximity, we hear, problems about excessive noise or, neighbors who don't get along or dogs barking that annoys a neighbor. And there can be threats and, maybe there are hostile emails being sent to neighbors or to board members or to managers. Occasionally we've seen some physical violence, even at board meetings, outside of board meetings between neighbors. Property damage. We've had cases where we've had, an owner deface certain, things in the community. And in one instance I can think of, there was damage done to the pool areas. Another instance, somebody defaced a bunch of signs, no trespassing signs in the community. We see just all kinds of different things happening. Maybe we've got somebody wandering in the neighborhood and they don't know who they are. Or, maybe we've had a situation in a condo where we have somebody with Tourette syndrome and they're, screaming and yelling in the middle of the night and disturbing their neighbors. So I think in almost 25 years, we've seen a lot of different people problems in how we handle things. One thing I'm going to say that you may not like to hear me say, but it is kind of important for me to say, is that we kind of do have to look at these on a case-by-case basis, because not every people problem has the same combination to unlock it to make the situation better. And different things work in different situations, depending on what type of disorder, illness somebody has. And so just the importance of having, a good relationship with your management company and with your attorney, and being able to pick up the phone and call them and say, hey, we've got this issue, here are the facts. What do you recommend? I think is really something that's important for your boards to establish, having that type of relationship where you can have a short phone call and strategize. And our firm even has kind of coined a phrase where we talk about, handling problems earlier in the process versus later in the process. Coming to your attorney or your manager early before this explodes to be on, Channel 3 on the news. And, I think that's something that you should really be thinking about doing early in the process, coming, together and strategizing on the facts of that situation. But, let's just talk about some hard numbers. So first, before we get into what our strategies are. The first thing is mental illness is on the rise in communities. This is a problem that we're hearing about all the time on a weekly basis, at least in my practice. And it could be situational anxiety, it could be depression, or various disorders personality disorders that we hear about, in the news. We're seeing them. We're on the front lines, right? We're dealing with people. We are also getting a lot of questions about aging residents, maybe residents that have Alzheimer's or they have dementia. And there are things occurring that we can't explain. Maybe we have a resident who's wandering around at 3 a.m. and they don't know where they live. Or we had a situation recently where we had a resident that, let herself into somebody else's home and thought it was her home. She didn't, was sitting in the living room and the real owner came home and, how to handle that situation effectively. We also see, I hate to use the word sociopaths, but it is a common word that is used, to describe a certain behavior. And a sociopath is somebody who has a personality disorder that manifests itself in extreme antisocial attitudes and behavior and a lack of conscience. So over the years, we've seen some different sociopath situations where, we have behavior. It could be a board member, it could be an owner, a resident. And how do we, deal with that person as we're trying to do our jobs running the association and they're wreaking havoc on us being able to get our work done and having a safe and healthy and happy association. We've also seen a rise with COVID of substance abuse and addiction. It's been a very large problem. And how do we deal with that and the resulting behavior that's associated with those addictions in your community? So let's just start out with some general strategies. So really the first strategy that I can give you as an advisor that's helping associations is first just listen to what the issue is, investigate the allegations that are being made about this person, and let's see what we can do to try to help the situation, would be my first piece of advice. So listen to what the facts are. You're going to be hearing about it from another neighbor. Maybe the manager is contacting me. Maybe a board member is getting stopped on the street and an owner's telling them about something that happened. Once you hear about this, I think the board does have an obligation to look into it, and investigate what the allegations are and do what they can to try to help the situation. Just yesterday, I had a call with a manager, and I love that he called me so early in the process. Again, it's the term that we've coined, preventative legal. He's practicing it by contacting me right away. Over the weekend, this particular manager had received complaints, and this is a large master plan community, and they have a full-time security staff on their team. They had received complaints from a resident about loud party in their neighbor's lot next to them at like 3 a.m. She said that there were a lot of people in the pool and that they had jumped over her fence and were making all kinds of racial slurs towards her. And she's an older resident, she's in her 80s. And really, she's never been on our radar before. In terms of, we've really never had any problems. We've never had any complaints from her before. So the security team that was on duty at that time went out to the neighbor's house, and all the lights were off. There was nobody in the pool. It was all quiet, and I think everybody was, perplexed by this, and so, we did a little bit more digging and investigated a little bit more, talked to both neighbors that were allegedly involved in this. The neighbor that has the pool, and, the allegations were against her that she was having this wild party and they jumped her fence, etc. And I think we all kind of came to the conclusion after talking with the owner who was complaining and the neighbor that this probably was an event that didn't happen, that it could have been like a delusion by the one neighbor. And it's just, it very likely didn't happen. And so what I recommended to the board was that we document the entire situation, which the security company had already documented their findings. We then documented in the file the findings that the manager had when he talked with both of the owners and what their respective sides of the stories were. And then, he said, well, what do I do with this information? Because, it's obvious to me that the neighbor that's complaining is having some issues, some cognitive issues. And, we talked a little bit about the owner. I said, well, what do you know about her? And, he said that one of the board members knew more about her, but their husband had passed away recently and she was living there alone. And, one suggestion that I had was, maybe is there a way that we might be able to get in touch with her family? And, we're not going to infer, we're not armchair psychologists or, we're not medical doctors, but just make the family aware of the situation that, hey, this came up over the weekend. And this is the investigation that we did. And we're just letting you know that this happened. And we would encourage you to check in with, the complaining owner. And so that's, kind of what we're going to do right now. The sad thing on many of these situations, especially on these aging issues, is, sometimes we contact the family and the family is in denial and they don't want to accept that their loved one is, potentially struggling with Alzheimer's or dementia. And so we often see, as we're navigating this as the attorney in the association, we also often see, a step up in terms of we see one thing and then we see something maybe even a little bit worse, something, and we pray that there's not going to be a tragedy, right? with each one, we should be documenting what's been done. So the strategy, to deal with some of these difficult situations, whether it's mental illness or it's aging issues, or maybe it's substance abuse and addiction. Listen to the facts of what happened, investigate the allegations, try to help the situation, maybe reach out to family members if we know who they are. Is there a city or state agency or a relative or a neighbor that might be able to help in the situation? We have to be careful how we frame it with all of these different, parties that we might potentially be asking to intercept and help us with. Just stick to the facts and just say, hey, we just want to make you aware of what's going on. And with the city or state agency, in my experience, it can be difficult to get them to intervene because, everybody has certain rights, and, the city or state doesn't always have the right to intervene in situations like this. Now, of course, if there's a dangerous situation, like the person could harm themselves or someone else, the city or state might be more inclined to get involved and help. But again, just kind of circling back to talk with your trusted advisors. Legal action may be necessary. We may need to send letters to the owner. We may need to go the litigation route if, things are really a problem. And I kind of go back to one of the examples that I gave at the beginning. Was the person with Tourette's in a condo, and they were, yelling and screaming at all hours of the night and keeping the neighbors on both sides of them awake. And, that was really a difficult situation for the association to navigate because the person that has the Tourette's didn't remember doing it. And so in that particular case, we suggested to the neighbors to document it by, getting their cell phone out and getting an audio of what was going on, so that it could then be provided to the owner so that they would understand that this is what was occurring in the middle of the night. In that particular situation, we ended up having to take legal action because the owner with Tourette's hired an attorney, and we ultimately had to file a lawsuit regarding the ongoing nuisance. And ultimately, the lawsuit got the owner's attention, and the owner moved to a different location. But all these situations, I think I said at the beginning of this section, there's a lot of different, things in our world right now that we have to navigate. And let's face it, when you live in an association, it's, all kinds of people are there. And so it's likely you're going to have in your tenure as a board member, or if you're managing a portfolio of properties as a manager, it's likely you're going to run into somebody with mental illness or somebody with aging issues or a sociopath or drug addiction. And so just go back to the strategies that we talked about here today. Rely on your trusted advisors, reach out to them, listen to the allegations, investigate the allegations, try to help the situation in whatever way you can. Is there a state agency or a relative or a neighbor or a city agency that might be able to help make the situation better? And legal action may be necessary in the end. Okay, let's switch gears and talk a little bit about hoarders. I have had some really interesting cases pertaining to hoarders and residents that are characterized as hoarders, and the ensuing problems that having a resident who is a hoarder in your association can cause. We have, over almost 25 years, I have seen situations where the hoarding has caused like rat infestations. I've seen a fire from a hoarder due to the hoarding. We have seen where hoarders, don't pay their assessments as well as the hoarding. And I think everybody needs to understand that hoarding is a mental illness. It's recognized as a mental illness, and it truly is a growing problem in many associations right now. And so what does hoarding look like typically in an association? Maybe the resident hoards books, newspapers, trash, knickknacks, items that they picked up on sale in bulk, furniture, scrap metal, sometimes animals, rotting food, and everything in between. And it is a common problem. And like I said, it has already been identified as a behavioral illness. Hoarders are usually isolated and suffer from some sort of psychological issues that produce the clinical definition of hoarding, which is just retaining items of no value in quantities that interfere with the victim's ability to function. And so a lot of these hoarding tendencies are dangerous to community associations because they're a fire danger. Sometimes they do the volume of stuff there. Sometimes it can cause structural problems to the victim's, home. They can cause problems for neighbors like we talked about the fire and the rat infestation. I also had a case, many years ago where a resident she was a hoarder, and then she also had like 100 cats in a 1-bedroom unit in a condo. And oh my gosh, it was truly the worst inspection I think I've ever done. I had to actually go there. And when I came home, I had to walk inside the unit. When I came home, I took off everything that I was wearing and I threw it out because it was so bad. It was that bad. And I also have a colleague of mine who is an attorney who, did an inspection with a hoarder, and he picked up a pretty serious bacterial injury, infection. And so, these type of things, it's scary, it's scary for the neighbors. It's scary for the manager. It's scary for the lawyer who's coming out to, look at the property. So make sure that if you, do have a situation like this is something that it needs to be dealt with, and we need to take some sort of action. So what types of things can we do? So first thing I would recommend is talk to the owner. Or the owner, or if it's a renter, resident, you're going to want to talk to all parties involved. I would probably start with the owner of the unit and say, hey, listen, either you have a problem with hoarding, or, your tenant has a problem with hoarding. It looks like there's a lot of materials in there. We're concerned about the safety of your neighbors, your safety. If it's a landlord situation where the landlord is the owner, you may want to talk to that landlord about possibly evicting the tenant, because the tenant could possibly cause a lot of damage to the unit if they don't take some sort of action. If the owner is a hoarder, you want to talk to them, possibly their relatives. If you have any knowledge of relatives, again, usually hoarders isolate themselves, so we don't always know if they have any relatives or not. We do have a system online where we can look up relatives of people to try to contact them in cases like this where potentially this person's in danger. The relatives may or may not be aware of the situation. I've had situations where we call the relative and we say, Johnny so-and-so is, living in our community. He's a hoarder. And they know exactly why I'm calling. And they're aware of the situation, but they don't know what to do it. So what are some suggestions that as a board, that we can do? It depends on how bad it is, but sometimes there are different groups that will come in and help do a cleanup, whether it's a church group or a trade group. That's something that we can offer. But in my experience, the hoarder doesn't see it as a problem. And so they're not going to accept that, because why would I need help cleaning up my lot or my unit? Everything's in order. And so, that may not be something that they'll take you up on. Maybe if it's somebody who's not, who actually can use help and who is able to accept help, that might work in the easier situations. But in my experience, in the harder situations, the hoarder's going to say, oh no, I don't need any help. So the next thing you might want to do if you have a hoarder is look for resources to help you. Maybe contact the city or municipality that the property is located in, and see if there are any neighborhood programs or code enforcement might be able to issue violations if there's a code violation here. And so these are resources that would be inexpensive and free, and that the association might want to consider reaching out to help us deal with the hoarder situation. If the clutter is a potential health code violation, you may be able to contact the Maricopa County Environmental Services Department. And their contact information is 602-506-6616. Or you can contact them just by going to the maricopa.gov website. And the Environmental Services Department for Maricopa County may have some resources that they might be able to help you with, depending on the facts of your situation. In fact, the department may send an inspector, issue a citation to the owner, ordering a cleanup, and take further action if the owner does not comply. From the association's perspective, it is obviously easier to have one of these third parties come in and help us get this cleaned up, whether it's in the municipality, the county, the city, a trade group or a religious group that comes in and volunteers to help, versus having us get involved and go in there and clean up, which from a liability standpoint, I would not recommend having volunteers in the community or board members going in and helping clean up the clutter. I think there's too much liability, and I think it's a health danger too. Okay, so let's say you try all of these different things. You try to get the owner to do it themselves. You offer assistance. You go the route of having, a state or local or federal agency come in and help, and that doesn't work. And then you have to think about enforcing the association documents and sending demand letters from the association's attorney, potentially filing a lawsuit and having a judge order that the owner clean it up. And if they don't, they'll be held in contempt of court. All of these different options that you have can help you if you do have a hoarder on your property. But again, reach out early, because the earlier that we address these problems versus the later, it's obviously significantly easier to get compliance from the owner. So just think about the different options that we've talked about here today as you're navigating if you have a hoarder in your association. But remember too that it's an illness. And so focusing on the owner's need for help so that they, once you get it cleaned up, that they don't just go right back and do it again. We've had cases where that's happened, where the code enforcement comes in, requires the owner to, get everything cleaned up. And then the next thing we know, 6 months later, we're right back where we are, where there's, a fire danger again, et cetera. So recognizing that it's not just the cleanup, but it's also, getting the owner to recognize that this is an illness and actually getting help. And that's really probably not our role as the association, but sometimes the family intervenes and helps us get that person that help. Okay, so we've covered a lot of different topics here today. We've covered, hoarders, we've covered sociopaths, we've covered aging issues, we've covered substance abuse, and we've also covered, all kinds of different mental illnesses and how to deal with owners and residents that may have some of those problems. Now let's talk about just plain old difficult people, and how do we work with difficult people, and what's the best strategy for difficult people? Maybe people that don't have any of these disorders or illnesses or aging issues, but people who just are personality difficult, right? And so first thing I want to share with you is we have a couple of cheat sheets that I think would be helpful as if you have difficult people in your community. And how we see the difficult people come up is either the difficult person's on the board, or the difficult person is a resident in the community who's unhappy about something. And so if you want to do a deep dive, these two cheat sheets are awesome resources for you. Again, you can find all of our cheat sheets on our webpage at mulcahylawfirm.com. But my team's going to be sharing them with you here. The first one is a cheat sheet called Dealing with Difficult People and Harassment. And then the second one is our DISC personalities cheat sheet, which is how to effectively work with people based upon what their personality type is. And so I think those are really helpful resources for you. So the first thing to remember, if we're going to talk about personalities, is sometimes you just have to understand the personality type that you are dealing with when you're on the board, or when you're a manager, or when you're your association's attorney. Frankly, anytime I go into a meeting with a board or a meeting with a difficult owner, I'm looking for warning signs to try to determine what type of personality the person has, so that I can speak the language that they understand. And I can, if I do that, I can establish a rapport with them and hopefully be able to find some common ground. So really, there are 4 different personality types where I really like this DISC personality analysis. And there's, it defines a different personality type. So there's like the direct and dominant personality type. And then there's the, steady, stable, doesn't like to fight personality type. If I know who I'm dealing with in my meeting, like, for example, let's say that I have a meeting with somebody who is the direct dominant type personality type. And actually my husband's that personality type. So I'm really up to speed on that one. If you are having a conversation with them, you need to get in and get out fast on the conversation because they don't want to spend 5 hours talking through an issue. So understanding who you're dealing with. And if you have like that detail nut personality type, which is the C personality type, you're going to have to spend 5 hours with them to get, what you want. And so, I even deal with this with owners on cases. We will I have a case right now with a particular association where the owner is suing the association, and the owner is a detail nut and he is a nitpicker. And, that's why we're involved in this lawsuit. This person wants large amounts of records. They, are going to exploit any minor infraction by the board of any law or any of your documents. And, they're not going to be happy until everything is done perfect. And so you're going to have different personality types is the bottom line. So I would encourage you, take a look at the cheat sheet because it tells you about the different personality types. It tells you what their strengths and weaknesses are. It even tells you who the celebrities are that share the personality types. So it's kind of fun to read it. And it gives you suggestions on how you can effectively work with those people. So I think that's kind of a creative way to do that. Okay, let's talk just generally speaking. What does a difficult owner look like? So a difficult owner typically likes to criticize, cajole, pinpoint the errors of others, accuses the board of stealing things, making bad business decisions, just all kinds of strange allegations would be what I would say, without evidence. So not evidence-based allegations. And unfortunately, I have one of these difficult owners right now on my board. So my patience has been tested the last 3 years with this type of personality. So how do we deal with this type of difficult owner? If it's an owner in the audience and it's not a board member, you need to get their behavior under control at the actual board meeting. So having some sort of meeting procedures at the beginning of the meeting, announcing them and saying, no personal attacks, no interrupting the meeting except, at the appropriate time for you to talk. And then you need to enforce those meeting procedures uniformly. So the minute the person, interrupts or starts screaming or yelling or making, allegations out of turn when it's not their turn to be talking, you need to give them a warning. And then if they continue with the bad behavior, then you need to ask them to leave the meeting. And if they refuse to leave the meeting, you may have to adjourn the meeting if they're really creating a scene. Hopefully that doesn't escalate to that level. One way to help with difficult owners is have a homeowner forum at the beginning of the meeting. Give them a couple of minutes to, state whatever they're upset about or what they're concerned about. And it's not just a difficult owner, it's any owner who wants to talk at that meeting. And, then that's it. Then they don't get an opportunity to talk again, except at other appropriate times in the meeting. And sometimes that's a good way to handle it because it just allows the person to vent. They come into the meeting, they dump it all out on the table at the homeowner forum, they vented, and then they won't interrupt, the meeting throughout the meeting. So that's kind of a good strategy. Just make sure you have a time limit on how long they can talk. Another thing that you can do is if the owner is really agitated, make sure that you ask them what exactly is the issue that you're upset about, and deal with one issue at a time. And then, listen carefully because sometimes the difficult owner has some valid points, or maybe they have in fact been wronged. And so you want to make sure that you're listening to the issue and not getting sidetracked with their bad behavior, their screaming, yelling, foul behavior, bad mouth language, all that type of thing. Really listen to what they have to say. And then, after they explain what they're upset about, then, agree with any truth in their complaint, if there are any. If there was a minor mistake by the board, say you're sorry. Ask them what they want. What exactly is it that you want? I have a case right now with an owner who's a difficult owner. And I've asked him, recently in this case, like, hey, what's your end game here? What do you want? And the interesting thing was the homeowner couldn't even tell me what he wanted. And I said to him, do you just want, I'm trying to just dig it out of him. Because everything that he's suing the association about is moot, right? The whole situation is over and it's been, reversed. And basically he just wants the board to tell him that he's right. It's sad, but these are the type of things that we get when we deal with the difficult personalities. They want an apology. They want to be told that they were right. That's the C personality type. They have to be right on everything. And so he's waiting for that acknowledgement. And as the lawyer for the association, we could spend like $50,000 fighting about this, or we can just come and find some common ground with him and try to make the situation go away. So I'm going to be meeting with him on Monday. Can't wait for that meeting to see if we can try to find some common ground, because the issue's over. He just wants some sort of a white flag, I guess. And, we want to be careful how we, handle that, because I truly don't think my client did anything wrong. But sometimes we have to work with the owners to try to resolve things just for the betterment of the community as a business decision, and try to, get everybody, all parties to agree, hey, the way that was handled wasn't the perfect way to handle it. And going forward, we're going to do better type of thing to try to resolve it. Some other things that you got to be really careful with when you're dealing with a difficult person is do not yell back, do not argue back with them. That's what they like. That's their gasoline in their tank. And so if they come in and they're screaming and yelling about something and you scream and yell back, you don't know what you're talking about, you're wrong, that's not how it happened. They love that. And then it just escalates up to the next level. So be really mindful of that. Respond in a controlled, non-argumentative way. If someone on your board is a little hot on the temper, make sure that person's not responding to somebody. It should be your most calm and rational person. Don't respond with anger. Don't argue. Don't trade insults. Be professional. Focus on what the issue is and how we can solve it versus screaming and yelling and you're wrong and whatever. Show them if they're claiming that the association has stolen money, just invite them to see the books and records of the association and let them know that the financials of the association can be viewed by any member and we welcome you to come and look at them, those type of things. Sometimes things cross over into, harassment, where the difficult owner is now making threats, he maybe has physical contact with the board member. We got to be really careful on those situations. And in Arizona, you can go and get an injunction prohibiting harassment against an owner for any sort of threat of physical harm or actual physical harm. So if that happens with the manager or a board member feels that they are truly being harassed, and again, these are kind of hard cases to win on. So you want to make sure you have your evidence and your facts in support of your position. But if a resident has harassed you by making a threat against you or by having actual physical contact with you in a threatening manner, you should go to justice court and you should get an injunction prohibiting harassment against that particular resident. And they will have to stay away from you. The judge will order how far for at least 6 months. It can be renewed once after the 6 months expires. So keep that in your back pocket. And all of that, the details on all of that are listed on our cheat sheet. Okay, our last few subjects that I want to talk about, we kind of covered difficult owners now, and would be how to handle infighting on the board. So dysfunction in your board. So the best advice I can give you on that is you really need to bring in an outside party to come in and have like what I would call an intervention, where we talk through the issues that are prohibiting your board from working together, from why there's so much anger and anxiety and whatever's going on your board. Bring in a third party. Our firm does boot camps for dysfunctional boards. We don't call it that, just so you know. But we will come in, do a legal seminar, and my focus that day will be how to get this board to be functional. And something that we typically will do is we'll have everybody take the personality tests. We'll talk about how we're all alike and how we're all different. And then we're going to put all the issues on the table, and we're going to talk through what the dysfunction is about and how we can get past it. And I cannot think of, we've been doing those for about 5 years now, the boot camps to help the dysfunctional boards. I cannot think of one that we have done where we haven't had a complete positive turnaround in the association. So it does work. And it's a good way to hit the reset button for your association if your board is just not functioning in a professional manner or just can't get along. And so we'd recommend doing that boot camp if you're one of those boards in that situation. Okay, let's talk lastly about feuding neighbors. What does the board do when we got Hatfields and McCoys, right? How do we handle it when the neighbors are going at it with each other and we're getting, pummeled with requests from both sides that this neighbor's doing this, that neighbor's doing that. Their dog came over and pooed on our lawn. They had a wild party. They threw beer cans in our yard. They built a wall on, a millimeter of our property. I mean, I've heard it all. So what's the best way to handle it? Well, the first thing to remember is that a lot of these issues are neighbor to neighbor issues and don't affect the association. So it really depends on the facts of the situation. But we need to look at the facts and determine, is this an association issue or is this an owner to owner issue? And so some things to think about would be, it's usually an owner to owner issue, just so you know, in my experience. How the association could get involved in this is, let's say that one owner is discriminating against another owner. Under the Fair Housing Act, the state and federal Fair Housing Act, if the association is notified of any sort of discrimination, so that would be an example of this would be like, let's say that maybe one neighbor is, potentially or allegedly, treating another neighbor poorly because of their religion or their familial status, because they have children, or because the person has a disability, or because of their national origin. All of these things could potentially involve the association now, because if an owner is being discriminated against, the association may have an obligation to get involved. So you want to look at our federal laws cheat sheet on this. You can find it on our website at mulcahylawfirm.com. And it's just the cheat sheets tab. It's the federal laws. We have a whole section on the Fair Housing Act. So short answer is, when you have feuds between neighbors, and they're contacting you, get more information on it. If it doesn't appear to be an issue that involves discrimination or an issue that might involve like them building something with our architectural approval where we would have to get involved. It's really just like a behavior type thing. Sometimes we just say this is a neighbor to neighbor issue. You need to resolve it. Get an attorney yourself, or you need to resolve it between the two of you. You might be able to go through mediation through your city, town, or municipality. They may have a mediation program, but both of you would need to agree to that. There are some times when the association has to get involved. Like, let's say it's the drug house, or there's wild parties going on. Then you need to reach out to your legal counsel and get advice on the best way to handle it. We have seen the drug house situation, unfold, where one neighbor is saying that it's a drug house is the next door neighbor, or then the association may be getting involved because the situation is a nuisance, and the association has an obligation to make sure that there aren't any nuisances in the community that are, prohibiting an owner from having enjoyment of their property. We may have to get the police involved. We may have to file a lawsuit against the owner for the bad behavior of the tenants or maybe the owner occupants. So there are a number of different remedies. We just have to look at what the facts are. And the first pivot is this an association issue that we have to get involved in? If it isn't, then we point the owners in the direction of, maybe there's a state or a local agency that might be able to give them some assistance on this, or maybe they need to get their own lawyers and fight it out themselves. If it is an association issue, then do we need to get the attorney involved? Is this a fair housing issue, or we need to really look into whether there's a form of discrimination going on here, et cetera. So again, I hate to say this on this seminar, I've said it a lot, but a lot of these issues depend on the facts. So I think we've given you some great strategies today in terms of when you hear about a problem, looking at the facts, doing your investigation, getting advice from your trusted advisors, and looking for the resources that may be able to help you navigate this difficult situation. Thank you so much for being here for our 7th class of our 2021 HOA Condo Academy. Thank you so much to the neighborhood services departments from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Surprise, Tempe, for your teamwork and partnership with our firm to provide this free education on HOAs and condos to your residents in your respective cities, and put together amazing virtual classes where we can still stay connected and potentially stay connected going forward too, as we start to plan our classes for the rest of 2021. Just so you know, we have a great slate of classes for August through December 31st. So make sure you're checking out our website at mulcahylawfirm.com. Our seminars has a special tab on the homepage, and it'll list all the seminars that we have coming up. And check out the classes that we have. I think we have 5 more classes through the rest of 2021. And we also have some live in-person classes for the second half of 2021. So if you want to get back in the classroom, make sure you think about attending one of our classes in person. But truly, a majority of the classes are going to be virtual for the rest of 2021 and possibly into 2022, because there's a demand for these classes. And we always have a ton of people showing up on our online platforms. So make sure that you're telling your cities, towns, and municipalities that this is convenient for you and that you're liking this type of education so that we can continue providing it to you. So thanks again for being here today. Take care, everybody.